depends upon, well, where are you? I mean, I must admit my least favorite statement from an attorney is it depends. But in this case, it clearly does depend on where you are. And so one of the things that I'm hoping to share with you today is the development of a contract maturity model. I first built this probably around 5 years ago, and it's still holding up okay. It needs some essentially updates to it. But I think it is a useful tool and maybe something that we can jointly develop, and certainly would love to work with legal operators to essentially refine this model, because I think it will show you as we get there in a moment. One of the things that strikes me in this area is the sheer complexity and the diversity and all of the moving pieces and parts that we need to successfully put in place to get to the end game. And then the other piece of the puzzle, of course, is, well, then how far do we go? Well, that depends too. It depends upon your resources, the availability of technology, and of course, your willingness or concern around innovation. How far do you want to sort of move to the cutting edge? But I think it also really needs essentially a clear understanding of both the current and the future technology. Colin and I were just discussing that, this one of the most unfortunate things that could happen is investment in today's technology that is soon replaced and made obsolete. So as I prepared, I found myself more and more thinking about, well, can we build a useful model or to assess where we are and where we need to go? And I sort of built it around the sort of the standard model of essentially moving from basic to fully advanced systems, but starting to sort of understand what does it mean by each of these steps, and how much it would mean to, what would it take to move from one step to another. And finally, I can use it as a framework and utilize it to look at recent surveys to give you an idea where other people are in this journey. And so it starts off with, essentially where we are today, which is pretty much one-off. Essentially, we essentially manage one contract at a time, and we're moving essentially to centralization. We're collecting all of those contracts into one, maybe sometimes multiple repositories. At the intermediate level, we essentially need contract management systems to be able to essentially store our contracts. As we move to the advanced level, we're talking about tools around the whole life cycle management. And finally, at the sort of the highest level, we want to build systems that are fully integrated with other platforms. So to give you an idea of essentially, I built this slide probably around 5 years ago, and so it's still holding up okay. But you can kind of see then all the different pieces and how many different components there are. Now, I'm going to make these slides are available to legal operators. There's much too detailed, quite frankly, to go into each of these components, but we can look at it at a high level. I think the sort of the piece that comes through for me is just the enormity of the steps and challenges ahead. We've seen essentially already the sort of layout, or sort of the one-off, the ad hoc, to moving to basic, to intermediate, advanced, and integrated. But this is starting to look at it through 4 other dimensions of what does it mean from the people side, essentially going from essentially all the different individuals working autonomously right now and not working together as we move through it and establish essentially teams. The process component. All of these can be the subject of a great debate. I recently had a discussion around, well, should we build in some kind of very complicated, strict workflow process into this component? Part of me says yes, but I also know from practice times for me that, workflow is one of the interesting things is that, particularly with lawyers, tend to be very pragmatic. And an excessively rigid workflow system may not be something that you would want to prioritize at this stage. Maybe as we get to a more standardized, process-driven, it would make sense to put it in. In terms of the technology, as we sort of move forward, we're essentially moving from a world today in which we use a range of technologies, but primarily manually. Email for workflow, word processors for the creation and review of contracts. And we're moving more and more to essentially dedicated systems to be able to handle essentially the process of essentially creating, reviewing, managing, and maintaining the contracts. And it's just helpful, particularly when you get into the right-hand side and you start to sort of build out, well, where is that end result? How far can this development go? And the way that I see it going is that ideally we start to develop systems where it becomes more automated and the contracts actually become essentially self-organizing, self-aware, self-managing documents. But how do we get there? And when is it realistic that we can get to that point? The other piece, I spent much of my time on the bottom row around content, around creating standards from existing executed documents and how we essentially build those into contract templates, clause libraries and the like. Then how do we harmonize and integrate all of those templates and clause libraries into unified systems? And how do we ultimately connect those terms to external platforms, such as payment systems? So again, please, if you have any questions, I mean, for me, this is just like a game board in which you might use it to say, well, where am I in each of these particular cells? And where do I realistically think I can go to? And of course, you may well have and very will likely have different responses in different parts of the matrix. You're going to be in different stages in different parts of this process. The next piece that essentially I thought a lot about is around essentially when we think about, particularly on the technology side, if we're going to move from everything is manual and one-off, essentially start a new contract, typically from the last closest draft, and just go through it, as I did when I practiced many, many years ago, and mark it up. So essentially, I think of the stage 0 is that the entire process, now I might be using things like email and word processors, but really everything else is really coming from the professional. I see the journey then as that light blue being the sort of manual process, with each step becoming a smaller and smaller piece of the process. And we start off with essentially, at the ad hoc level, we may have a number of repositories and our systems may be limited to just searching using Control F. Still use it today in many cases. So then how do we start to move forward, and what are the different steps that we might put into here in each of these stages? And again, you can sort of mark where you are today and where you hope to go in the next few years, and what would it take to get from current stage to the stage that you would like to get to, and whether the technology is mature enough for you to feel comfortable doing so. So again, I sort of started to write down on the, Colin.
I don't want to interrupt your flow, but I just want to ask a question to kind of put all this in perspective. Like if I'm a legal operations professional thinking about building out a new AI platform, whether it's on contract management, like what am I thinking of? What am I laying out? Like what am I laying out? Where are the gaps that need to be filled with that AI doesn't fill? Just kind of, if you can kind of frame it around that with this model.
Yeah, we're certainly going to look into specific examples of that, but I would give the sort of, at this stage, sort of a general answer to that, in that essentially all of the pieces of the process today are done by humans, by experts. Which elements of those can be essentially implemented or augmented with technology. And there's a full range of them, essentially in the, first of all, finding stuff. Moving from Control F to essentially thinking about how I might automatically build smart search systems that can search for particular terms, particular contract types containing particular provisions. I could go through, as in the old way, and manually tag and profile them. But a modern AI system should give you the capability to both extract out of the document key contract terms and the clauses for you to be able to search on them. Next level might be then, well, I need to generate a new document. I can create essentially a document assembly system. And again, what that typically requires is that I could ask the expert to say, well, think about all of the different components of the documents, the standard terms and all the alternative terms, and help me build a decision tree to essentially help other people build a contract based upon that expertise. Or use AI to be able to data mine all of your existing precedents, find where your standards are, where the variations are, and come up with an automated integrated playbook. And I can go on, Colin, and say, then in the next stage, what we might do is that today, when it comes to contract administration, I can essentially go through the document and extract out of the document all the obligations. And that is an incredibly time-consuming task. Or I might use AI to be able to help me extract those obligations into a contract management system. So I would say generally, also, I'm going to give specific examples as we go through this. Every step of the contracting process that we do today that is essentially time-consuming, complex, or in some cases, it's simply overwhelmingly large, then we may want to harness AI. I mean, I'll give you one example where it just simply wasn't possible to do it on a manual basis. I did an analysis for the procurement department of the Canadian federal government, and they wanted to be able to analyze all of their past positions, but they really wanted to take a comprehensive view of it. So they wanted to go back 3 years and look at all of their procurements, or at least 1/3 of them. And they do a lot. I mean, they spend nearly $25 billion a year. And looking at the sort of the scope of the problem, had I done it the way I used to do it manually, I would have printed the documents out and worked my way through them. The only problem in this case was that had I printed them out, the stack of papers would have been 120 feet high. It just couldn't be done. An army of people, but the cost would have been simply, beyond the tolerance of the government to go ahead and do it. Harness AI to be able to data mine and extract all of the key terms out of those systems. So I think everything that we do in the contracting basis essentially is an open candidate to consider, do we have some technology today to help us do it? Maybe not do it essentially and just give us answers, but give us insights on what is in that system so that I can use essentially the platform to make better judgments going forward. Not have the machine try and make those judgments for me, but just gives me insights in what's in the collection so that I can improve it. Colin, does that answer your question?
It does, Kingsley. But just on your last thought there, like, what are the limitations? Is that the real limitations, that the AI won't make judgments for you, or is that something that hasn't evolved to yet?
Well, I mean, judgment clearly, judgment is absolutely the sort of the most complex capability. But I mean, some judgments, if we're talking about repeatable transactions or repeatable decisions, then we should be able to essentially build into the system an output that would give us the same results that a experienced professional would say, that is the exercise of good judgment. I would do the same thing. As we get into more complex areas, then we're open to more and more nuance. But that's also true. So one of the ways that I've always thought about it is that judgment is encapsulated many times in the artifacts, the documents that we analyze. The past history of all of those negotiations represents the collective intelligence of the lawyers and contract professionals that were involved in those transactions. And the ability to be able to unlock those, essentially, those past decisions from that collection, I think is truly insightful. I mean, I think about it many times. For example, when I was doing this inside of law firms, the last thing that they wanted was my judgment about how those partners who've been working together for 20, 30 years were dealing with these mergers or other transactions. We needed to be able to look into the system. And now we have the tools to be able to really capture, or I think of it as reverse engineering, the legal logic that is in that document set. So again, may I ask, ask a question, or because I'd love the follow-ups. Is there?
No, that answers it. There's just one question, like from AI being such a buzzword, like for the past, it must be about 4 or 5 years now, where everybody and their grandmother is talking about AI, right? It's like, it seems like from what I'm seeing in the market, there seems to be a resurgence of like the AI capabilities. But I'd love to get your opinion on like where we are on the, on the bar chart. Like, have we come far in the past 4 years, or is there so much work to be done for this to be kind of fully utilized?
There is a lot of work to be done. Let me answer that I'll try and answer that in a couple of different directions. In certain areas, we have come an extraordinarily long way, particularly in search or classification, which is to take a piece of a contract, a clause, and say, what is the nature of this clause? Is it a limitation of liability? Is it an entire agreement clause? Is it a payment clause? We're very good at being able to identify what it is. But to understand its true meaning and significance, given the sort of level of complexity of some of the language that we are looking at, then there are limits. But to what I would say is that one of the ways to be able to make the technology more capable, quite frankly, is to create more simplified, standardized contracts. Because as you and I were talking, is that in some cases we were just doing an analysis of a set of really complicated limitation of liability clauses, and the operative sentence to determine whether or not a claim was capped or uncapped was in a sentence that was probably over 10 lines long. And whether or not it essentially was capped was in many cases dependent on the location of a comma. It is exceedingly complex to the extent that while the technology would certainly be challenged to understand the meaning of that, so are the lawyers, including myself. In looking at those contracts, it took me a while to be able to break them down, to be able to understand what was going on in them. And even then, quite frankly, it was still open to interpretation. So I do think there absolutely are limits, but we can better manage those limits if we, at the same time, introduce some simplification and standardization. And I know in some cases, there are many people who would not feel comfortable with us essentially rewriting their contracts so they could be better read by machines. The second sort of vignette that I would offer in this case in terms of what is the limitations, I can offer another story. Of a few years back, I reached out to DARPA and NIST, DARPA being the Defense Advanced Research Projects Agency, and NIST being the National Institutes of Science and Technology. And I was keen to see if they were interested in doing something like the Autonomous Car Challenge. Could we essentially have a 3-stage challenge whereby we would draft a clause, draft a contract and negotiate a contract, and that the participants in doing this will be a combination of human experts and machines, and the judges would have the task of essentially deciding whether this was the Turing test. Was it written by a human or a machine? Now, I was pretty sure that we could actually do well on the first two, because in terms of limitation of technology, today it's really good at data mining existing material. It is limited in its capacity to create new. But that's where it's changing. I think that is the interesting threshold going forward, is to simply pull from existing or create something new. With the rise of things like GPT-3 from the OpenAI project, there's probably seen in the news this pretty remarkable ability, quite frankly, to create a news story by just starting the story off with a couple of sentences, and it will pull through, essentially then create the rest of the story. And it's pretty good at it. A lot of people, many people, would be fooled by it. Now, we actually, a few years back, we tried that on contracts, by the way, and gave it the first few clauses of a confidentiality or an NDA. And it did create the rest of it. It looked good. It looked like a contract. It didn't read like a contract. But it was pretty remarkable where it was at that stage. And it is getting better and better. I think that the next stage is not us, machines drafting contracts. I mean, that the robot revolution hasn't got to that extent yet. But what we can do, and we are actually doing it, is essentially we have our standard and we have the history of all of the things that we previously agreed to. And the other side essentially adjusts it. They mark it up, redline the document to us. And what we can do today is that we can look at essentially our standard and our fallbacks and the other side's changes, map them up to our fallbacks, and surgically make the changes to the contract to insert essentially our compromise position that we hope the other side would agree to, i.e. first line, red line review that we can do, not by creating a new clause, not replacing the clause with our standard, but surgically injecting what is effectively a compromise. That, to me, are the limits. That essentially we're talking about complex language. We can essentially make it better if we simplified it. We can start to data mine all of our essentially past contracts and be able to see if there is a pattern that allows us to be able to come to an automated review of the other side's red line. That's the bleeding edge today. Colin, do you agree?
Yeah, I agree. You preach to that.
Yeah, well, essentially, we can actually talk a bit on the next slide. Is I'm often curious about this. Is that I'm a big proponent of standards, but I have two challenges with them. Will people use them? And what standard are we talking about? Would there end up being many standards? A West Coast standard of a license agreement and a East Coast standard? Probably. But I still think that a bit like the technology chart, everything today is different. And we can use the technology to start to rein it in. And the way I think of it, I'll show you some examples in a second, is that what we can tell accurately with the technology is your de facto current terms, what you have agreed to in the past. And with that, and once we start to create some high-level views and reports, we can start to work with our clients and say, well, this is what you've agreed to in the past. I mean, essentially, you're only getting your standard LOL 10% of the time. You're getting pushed back 90% of the time. But we know there are patterns in those pushbacks, and some of them clearly are acceptable to you. So let's just take that infinite variation of the 90% and start to essentially group them into acceptable fallbacks. So instead of having, one standard and 90 difference, maybe we could actually have slightly over half of them in our standard or one of the fallbacks. It's a step in the right direction. And I think if we start to go through this, really what it is this sort of step view of the world, where green represents sort of variation. The number of variations essentially become less and less because we see the patterns in the existing documents, and we can use it to be able to harness those into a set of agreeable fallbacks or alternatives. Once we've narrowed this thing down, we start to get to the last piece that you were raising, Colin, which is that once I'm in a more standard framework, I can start to essentially do many other advantageous things, which is harmonize the language of those clauses across the playbook. Do I need a different indemnity in my master service agreement, from a SaaS agreement, from a license agreement? Probably what we're going to find is there is a standard and 4 or 5 fallbacks, and I can now manage it from a centralized library rather than having to essentially adjust those terms in every single template. It is a huge savings to be able to harmonize and unify, essentially your library. And once I've got it there, once I got them into the standard, I can not only sort of look at optimize them, but I can start to essentially build in tools that connect them to other platforms. It'd be extremely difficult today, given the enormous variability, even in a payment clause, to link it up to an ACH or blockchain system. If I started to have standards and I could build them into it and tag them in the document, as you'll see, we will be able to connect them.
Yeah, my comment here, Kingsley, there's a lot going on here. Like if you're looking at all the different stages, like to get to the optimized stage, it's like an industry lift, right? It's like, are you going to have like ABA standards across the board? When if you look at the law in the 50 states is currently different, right? But contract language, it seems like such a heavy lift to get there. You think like you'd have to do it by like piecemeal, like company by company.
Industry by industry, and we move up. But one of the advantages that we have is that there are 2 ways to think about standards. There are language standards, and say, for example, you put a few clauses in front of a group of lawyers and get them to agree upon the actual language. Probably not going to happen, as you're pointing out. We've all got our own opinion.
Battle of the pins.
But what happens if, it's a bit like you learn in law school, is that what happens if we focus less on the actual words, but on the principles or the concepts behind it? And when we look at, for example, the building blocks of one agreement to another across, it's a similar agreement, different companies, different industries, they all built upon the exact same systems. And they're all based upon the same foundation. An indemnity in Switzerland is the same as it is in Singapore. A warranty is the same concept in Germany.
But like even when you boil down the language to its essence, right? It's like it's all about risk mitigation, right? And it's got a value on it. And I know that this is something that you're pushing right now, right? The valuation of a clause. Is that where it needs to go to be able to kind of streamline this effort and put attorneys out of business? I'm joking.
Well, that's not the goal. But essentially, one of the things that risk analysis does give you is, quite frankly, the objective data to determine, is this worth fighting over? In most cases, am I okay with the standard? Because the likelihood that it would ever be triggered and the probability of claim is so low. Now, in certain areas, we do want to focus on. So that's one of the propositions that I've always been focused on, is pick your fights. Maybe we can't essentially standardize, service levels, warranties, but there are a whole bunch of the parts of the contracts that we can, because they have low risk.
Is there a way of grouping certain language into a risk category, like based on, AI reading that clause and say, hey, this is a 3 versus a 5, which is like, more tolerant or less tolerant,
Yeah,
depending on how you score it.
the way we built it, actually, is really I think we have a white paper around it. It's really built around two components. There is inherent risk and deviation risk. So, for example, an entire agreement clause or a counterparty clause has low inherent risk. But you've also got, whereas an indemnity has a high inherent risk. And then the other thing that we can measure is essentially deviation from our standards and fallbacks. So even a minor deviation of that, the language from our standard indemnity is going to raise essentially a higher red flag risk. So it's two pieces: inherent risk of the clause and the deviation from the standard. There is one more piece that we would love to have, empirical data around the essentially when in practice has, what is the impact in practice of those terms. I've done a lot of studies in this area where, for example, the lawyers have traditionally sort of built risk aversion into the language and built them very complex, essentially thrown the kitchen sink at it to cover everything. But we know from essentially other data analytics that long, complex contracts cost more. They cost more to create, they cost more to negotiate, and they cost more to administer. So if we look at, for example, then essentially the litigation and claim history, we know essentially the cost of exposure in the current environment. And every study that I've done in this shows us that there is more risk aversion, more cost built into the contract than would be warranted by, for example, a self-insurance system. So we do have increasing data to help us. It would be good to have industry data to back it up. But those are the components that we look at. And using that inherent and divergent risk is very helpful then when you're reviewing a contract to just focus in on the 2 or 3 things as opposed to every single deviation that make a difference to your organization. And again, it's using AI to be able to focus your attention on the high risk situations.
This is fascinating stuff, Kingsley. I'm going to let you get back to the presentation. Jump in a minute.
Oh, I'm enjoying the questions. I wish others would jump in too. But
if anybody's got questions, be sure to put Kingsley on the spot, guys. Come on.
Oh, please, yeah. Yeah, please. I really enjoy the questions. I thought the next piece of this, I use this model framework to see essentially where's the market, and it was interesting. Last year, the Association of Corporate Counsel published a survey, and I could see some of the language that they put into these. Essentially, they created a survey around essentially contract systems and build essentially early stage, intermediate stage, and advanced stage. And it was really interesting. There was a pretty close mapping, in some cases down to the word, of the earlier model that I built. I'm happy for that because I really do think that we should collectively create systems like this. So my basic intermediate advanced essentially maps to the early stage, intermediate, and advanced stages. And then their survey of last year gives you some sort of interesting idea of where the respondents are. And essentially the mean is sort of this intermediate first stage, which basically translates to, we do have a contract repository. We don't really have a standards. We don't really have a playbook. And compared to all other areas of legal operations, this is relatively low compared to, say, compliance. Most organizations are much further along the process than here. So I primarily put this up that no one should think that, they're already at the end game. And people should take comfort that we're sort of learning as we go along here. It is, as all of these slides have shown, really complex, multifaceted, essentially journey that we're on. So just a sort of comfort slide. But I think there's a lot of information that you can gather from the Association of Corporate Counsel material of last year, and the World Commerce and Contracting also has a very good study of the components and benchmarking of contract maturity. Useful material, and I don't know if Colin would be good to sort of start to collect it together, because I do think it would be helpful for people to work together and understand where they are and where they're going using models like this. But now, sort of moving on to the sort of the nuts and bolts, essentially, how do you get started? What are the steps associated with it? I mean, well, the first things is that, I mean, as I just pulled a quote from my colleague in crime, Derek Shuren, that this I've known myself for years, but this really captures it, that 92% of companies really want to know what's in that ground truth, what's in their existing agreement. They have no idea. And it's kind of understandable. It's often the case that, when I sort of apply the analytics to a set of contracts, often I will know shortly that as we start to run this process, I'll know more about their contracts than they do. Because I'm able to take, rather than simply look at the detailed words of every contract, I can create summaries around it and understand where their standards and deviations are. And until recently, it was something that analytical tool was really sort of a complex black box that few had access to. Now we're opening the box up, and you will be able to essentially, if you collect your documents, be able to analyze them, extract data out of it, be able to find that language, that comparison the language, see the areas of deviation, and start to organize your contracts and clauses and generate reports out of the system. And it was okay. I mean, for me, essentially, I can show the Accorda platform here. I'm not privy to any others, but this is the results called insights of essentially putting a set of, in this case, I think it was over 400 master services agreement into the platform. And what it does is that essentially compares each of those documents to the standard and determines what percentage of clauses fall into the standard, which percentage of those clauses fall into one of our existing fallbacks, and which are essentially set by the other side. One of the most interesting things about this, when you look more and more data sets like this, is essentially, where is that pushback? Where is the deviation coming from? And in one case, we're working for a government, it was, I guess, to be honest, in retrospect, not a surprise, but it was a revelation to me at the time that 80% of the variation was coming from internal sources. They could have created, they were essentially harming themselves by just coming up with all the variations. And in fact, that study really told us something, that this actually came from a government group, and they had a template.
Quick question on this.
Yeah.
I'm just looking at the analysis here. It sounds like with this analysis, you've already built your playbooks, right? By
couple more steps to go to playbooks. I think this gives you your ground truth. Your playbook needs a little bit more refinement, but this does tell you essentially. This clearly points out your friction points. Yes. Where you want to, and particularly you want to study these others, because are there patterns and groups in here that really represent fallbacks? That had I put them into my system, I would have got them into many of these into my standards. So this is ground truth that gives you the sort of the information that you need to be able to make, essentially move to the playbook.
So is that like a historical view then, like post execution?
Yep.
On all your data, like, and you get percentage allocations for every time things were used. This is fascinating stuff.
Yeah. So and essentially, it's not only there's many levels to this analysis. Typically today, we have your starting point on your end point, because that's all we have from a historical viewpoint. But you can imagine going forward, we're actually going to have every single step along the way. All of the, essentially, the negotiations back and forth, which ones were accepted, which ones went through multiple reviews, which ones held the deal up. I mean, this is, at this stage, for many companies, we only have beginning and end, and it tells us that divergence.
Yeah, you find out where you bend as well, right? And what language you've accepted. And
once we get into the negotiation history, it becomes incredibly powerful, and we can start to sort of, give people a sort of advice in real time and say, 80% of the time people take this fallback. And so we know essentially to help us direct it, but it goes further than that. So here, essentially, we can see I brought up my typical limitation of liability, true set of documents. We've only got 20% on our paper. Haven't even got many into our fallbacks. We're just getting pushed back and losing on that one. And that's at high risk and marked as such in this analysis. But the other piece of the puzzle, we can obviously go down into the detail and see the exact wording of each of these differences. And this is where it starts to become really interesting. That in this case, we see, and it's not uncommon to see a sentence that's tacked on the end. Black test is the same, hasn't been changed. Red strikeout test has been removed and green's been added. And here we see essentially a carve out. And the system today can essentially go through and look at all of those the 90+% of the ones that we put in other, and actually group them into a set of candidate fallbacks. And then we as essentially, you can either just approve them, you can review them into the system. So it becomes essentially a much, much quicker way to build your playbook.
Wow.
I'm going to show you a couple more before we get into playbook building. This is another one that I did, essentially looking at the history of a set of documents. This was actually a real case. This was the analysis of a set of RFP responses. And just looking at each of the clauses here in the vertical, each of the documents. And the intersection is a clause from each document marked up in terms of essentially how conforming it is to the standard. So it's interesting in terms of a heat map. You can see, where is the greatest variability? Well, no big surprises here. Indemnity and limitation of liability. The other thing that this was used for in practice was that actually they were put into 3 quadrants. The first quadrant, where we saw limited variability, went through to the second round of the RFP. The second one went through to the second round, provided they were willing to change high variant clauses to one of the standards, and the high risk ones were excluded. Interesting enough, in this case, the incumbent was on the far right. But actually, this chart was actually used by the senior people in the company, CEO levels, to explain to them why it was important for them to bring them in line. But the next bit, now we're getting short on time, so I just want to show you essentially how we build playbooks. Another piece of the sort of the studies that we've done is that almost just a handful of companies have comprehensive and current playbooks. Most don't have them, or they're not current. So, essentially, as written here, virtually everything is negotiated on the document. It's either not fully up to date or non-existent, or it may not be. Essentially, for me, when we see lots of them, it's an Excel spreadsheet, clearly understood that by the person who created the spreadsheet, but really difficult to understand and be actionable by others. So what we need to do then is to think about essentially the format, not just a Word document or sentence Word. It needs to be integrated into your platform. Let me just go forward. What is its form? Is it just to say just a list of fallbacks? Actually, our best practices show that it should be issue driven. There's a question that the other side is driving to, that we're trying to essentially understand, not just simply to say, here's fallback 1, here's fallback 2. What is the issue that they're raising so that we can offer guidance and give examples? And Excel, for example, the Word, essentially playbook is simply just got a copy and paste. The better system is one that is essentially automated or at least augmented into the contract review. I'm just going to show you an example of that. That, here in the in the assignment clause in here is going to essentially, it sees the red line that was tendered by the other side. And I don't know about you, I find red lines exceedingly hard to analyze, but it does a good job of marking it up. And then what it will do then is essentially read that and determine what is the issue that is raised by the other side in this particular case. And as the counterparty essentially wants the ability to assign the agreement to their affiliates. In most cases, we can look back at past history and say that's not an unreasonable request, and one that we have agreed to 80–90% of the time. So we know essentially what the issue is, and it's written in sort of plain English that people can essentially understand. And then we have essentially the markup as to what we would do essentially to change the language of it to this particular acceptable fallback. Now, early on, and I think essentially this is at the cutting edge capability, some systems might simply have replaced the language of this clause with ours. But as you know, that would not be acceptable in most negotiations. The better way, the most challenging way, is to surgically inject that language into this clause. And this is capable of doing that. So I'm just checking time and questions here. So Colin, yeah, I was trying to synthesize the question. Okay, so can we, it's a very good question. It's essentially, we're putting our variations into a set of sort of groupings or quadrants. Can we train essentially the tool to be able to map it to the quartile? Actually, we can go further than that. We can teach essentially the machine will first of all automatically identify the fallbacks, which are basically, you can describe as frequently accepted variations on our standard. And the threshold is what percentage of variations would we want to essentially say we want to accept this as a fallback, and how many fallbacks do we really want to offer our lawyers? I mean, we've seen systems that there may be 30 or 40 fallbacks. It's tough to use. So I think there is both a sort of a usability threshold of the number, but the machine is actually capable of creating as many fallback variations as it sees in the patterns. And it's really up to you to essentially, or your turn is to say, I want to agree to that as one of my acceptable fallbacks. And then it can use it within the system to say, yes, this is acceptable. You do not need approval for this particular variation on the theme. So I hope I answered your question. And then essentially, I'm just going to move through very quickly through the end here as we move to the next stage. What does it take to go from intermediate to advanced? Obviously, you want one repository for all of your contracts. You want a full suite of all of the contract lifecycle tools to create, review, execute, search, and analyze. And you want a tool, as we were just discussing, to start to harmonize and standardize and, quite frankly, rein in all of that different types of language so that you can better map them to essentially your risk system. This is what it looks like in terms of a searchable repository on the Corda system. You can just upload the documents. It's going to essentially pull out of it key terms so you can search on governing law, you can search on counterparty, you can search on term, etc. So it just makes it very easy to put it into a single repository. So my last few minutes, if that's okay, Colin, I would just like to very quickly sort of go through what I think is sort of the next stages. In an ideal world, we would have essentially systems, contracts that were actually capable of taking care of themselves, perhaps even sending you an email and saying, I'm up for negotiation in 3 months. The terms of this contract have changed compared to our new playbook in these places. Would you like to propose essentially a new amended update? It takes care of the payment systems inside of it. It becomes self-administering. And what a lot of people have essentially proposed is that we create these so-called smart contracts. But even though essentially I write software, I'm not a proponent of writing a contract in Python or C#. While it would be completely automated, it would have a number of different essentially deficiencies. First, it'd be completely inaccessible to most people, wouldn't be able to read them. And for those of you who have written and debugged software, I can't imagine the nightmare of debugging a contract system that is making payments and essentially making risk assessments. It would just be so difficult. And it's also fundamentally unnecessary. There aren't that many terms in a contract that need to be connected to other systems. So one of the things I've become enamored with lately, even though it's been around for a while, are what's called essentially Ricardian Systems, in which essentially sort of like it's both a human and a machine readable system in which we connect the sort of the world of law and contracts through the world of cryptography to, for example, accounting. So what it was then suggested, say, this was kind of interesting. This goes back to 1996. I think there are beginning to see examples of this. But if I were to put my crystal ball into play and say, where do I think it's going in terms of next steps, automation of capability, I think we take a look at the administration of contracts. We know that the cost of administering a contract far exceed the cost of creating it and reviewing it. So how can we deal with some of this sort of high costs in the system? Beginning to experiment with this, that we essentially, you have the contract, it's recorded as a matter of law, it's essentially digitally signed and hashed. It's then certain parts of it are linked like a payment system, whether through ACH or blockchain, to accounting, but you can still read the text of it. And we come up with a markup system to be able to extract, the key information out of it. Many people today approach it by writing a contract in the traditional manner and then applying technology to pull out all of the obligations in it. And it's not particularly accurate, so then you hire a whole bunch of people to be able to review the output of the analysis to be able to build an obligation tracking system. If you control the contract, one side or the other, you can embed this capability into the contract. I think it's likely to happen in the next few years. So that, Colin, is a sort of a vision of where we are and where we could be going.
I think that gives us, I appreciate it. I know we're coming at the top of the hour, but that just gives us a lot to kind of chew on. It's like I've got so much to learn in this area. I'm just a student trying to figure this out. Really appreciate your expertise and putting a spotlight on it for us. Just want to say to the attendees, thank you very much for being here. Really appreciate it. Kingsley said he's going to release the slides, so I'll follow up with a recording of the event and the slides later on. I just want to let you know, like, Kingsley's been like a real resource in this space, and feel free to reach out if you have any questions. Mm-hmm. Kingsley would love to share his knowledge. Again, thanks everybody from here. Kingsley, really appreciate it. We'll be in touch.
Thank you so much. I've enjoyed the conversation. Thank you.
Awesome. I really appreciate it.
Okay. Thanks, guys.